Okay, we are on record today. Continuation of the prelim on this particular file. We made a little bit of headway last time we were here. And we are getting ready to.
I'm sorry I wasn't able to attend, but I had a conflict and I couldn't break it.
Well, that's all right. We're back and you've been able to talk with your client. So we'll get started. Let's do appearances, please.
Good morning, Your Honor. Nicole Underwood, legal guardian ad litem for the minors.
Natasha Thomas, counsel for the department.
Chris Morak with the department.
Michael Brooks, I am the attorney for the father.
Stephen Johnson, I am the father.
Michael McFarland, representing Malika Remberg, who's joining us on Zoom. Is she on screen?
I was just looking for that.
Just call.
Okay, it looks like we have quite a few, like I have
Harbor Light.
Veronica Bresnay, Paula Mary, Heather Barris, Amy Fullerton also in the waiting room. How many of them do you want?
Well, I know Veronica is their foster care supervisor.
Okay, so we'll let her in. You want anybody else?
Paula.
Okay. Heather Barris, Amy Fullerton would be the only other department.
They might be for the trial.
Yeah, okay, perfect. There she is. All right, Malika, can you give us your name for the record, please?
Malika Remberg.
Hello, welcome. Okay. All right, I think we went over a lot of what we needed to do for our purposes of the prelim last time. There's an active Native American heritage search underway. If there's any update on that, I'll look forward to that. Mom wants to enter a plea, dad wants a jury trial, which we set.
Your Honor, we don't want a jury trial. My client and I have discussed it in the hall and we don't want a jury.
You like a bench trial?
Yes, please.
All right, so we'll leave that date.
But I would like you to ask my client about this.
All right, Deputy Ames, would you swear in, actually go ahead and swear in Ms. Malika Remberg and Mr. Stephen Johnson, please.
Mr. Johnson?
Yes.
You can raise your right hand. Ms. Remberg, please raise your right hand to be sworn in. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yeah.
Thank you.
Okay. All right, Mr. Brooks. Does your client have a copy of the petition? Or maybe I'll just, Mr. Johnson, do you have a copy of the petition?
Sir?
Yes, I received it. But yes, I don't have it with me if that's what you're.
Well, that's okay. I just need to make sure you actually got a copy of it. And you've had a chance to talk with Mr. Brooks?
Yes.
All right, so last time we were here, you had another attorney just briefly, and we set a jury trial, but do you want a jury or a bench? Meaning in front of the judge, me, or in front of a jury?
I was hoping in front of the judge, and the last attorney, like I was trying to reach out to her at the end of it, I really wasn't fully knowledge on the directions because I don't feel like that was the attorney led me the right decision. So I feel like I made a decision unknowingly of other options.
Well, it's okay with me either way. All right, so we've got you scheduled for December 20th, and you can still have that date. We'll just hear the case in court here without requiring the jury to be present. So we'll have the same date there.
So we are going to trial.
It's up to you. So you have the right to admit or deny the allegations in the pleadings. I'm sure Mr. Brooks has talked with you about that. If there's enough that you want to admit, then I would decide whether or not that qualifies as a violation of the statute to take jurisdiction, which obviously is a lot of legal terminology. So if you have questions about that, Mr. Brooks is well-versed in these cases and will be able to talk you through that. But maybe this is a better question for him. Mr. Brooks, have you talked to him about how he wants to proceed?
I have. My client does not believe he's guilty of anything. And we want a trial.
All right.
My client doesn't want a trial. He just wants you to give him his kids back today. But I haven't got that to offer.
Well, he can ask for a place. You can ask for placement today. And I'll hear that argument on that piece as part of today's hearing. So today I've just got to decide, and I already have actually, probable cause has been established to authorize the petition. But he can continue to request placement today. I can also set it for an evidentiary hearing on the issue of placement. I can't do that today. I might be able to get it in within the next week or so. Does that sound like something you want to try?
In plain English, if you admit enough of this petition, court will take jurisdiction.
Well, I'm talking about placement.
No, she already took jurisdiction. And today we're just here to discuss the placement. And
Well, both questions are unanswered, frankly. So they're separate questions. One is whether or not to officially remove the children and place them with your father. And the other one is whether or not I should take jurisdiction over the parents. And you have the right to a trial on the issue of whether or not the court should take jurisdiction over you. And the kids, really. I don't think the
My
GA
client is under the impression I told him this case was not going to amount to anything and I was gonna get his kids back today. I'm sorry he got that impression. All I really meant to say is it's not a strong major case. That doesn't mean it's gonna get decided today. But at some point, you will hear the evidence and that will determine whether you think this is significant or not.
On the question of removal, the situation right now, as I understand it, is that there's an agreement to let the kids stay at your dad's. Now, the department, and we had a brief bench conference, I want to put this on the record. I talked with the attorneys before we got on record. The department is asking for formal placement with your father, which would trigger things like funding, parenting time, and some other slightly higher structure. But it would essentially be the same plan, or it would be like the legalization essentially of the plan that you're currently under. So if you want to continue the safety plan until we can come back for an official hearing on removal, we can do that. That sounds like what you want to do. Is that right, Mr. Brooks?
Understand what the judge said.
yes, I understand. I understand what you said, but the part I don't understand was the safety plan because I haven't been submitted any paperwork or I haven't been sat down with, I haven't been even told what I can do about my allegations. So my particular point of view that I'm focusing on is how can I agree to a safety plan that I have everything looked over. And Chris, besides the day that my kids were removed, this is the first time that CPS even reached out to me. We haven't talked about any safety plans. We haven't talked about what I can do for your reunification, whether it's temporary or long term. We haven't talked about what I can do for myself. I haven't spoken to anyone. Only thing that they said to me was, I'm removing your kids. And they disappeared and they called me today and tried to get me a ride to court.
All right, so your kids have not been officially removed. My understanding is that there's an agreement that you're letting them stay with your dad for now.
It was an agreement that I made under the impression that I was given no other options from the influence of CPS.
Okay,
So it's a great agreement because my father is very great with kids, but it still is a lost empty agreement because I don't understand exactly what I'm doing. I'm just doing what's best for my kids for now and hoping that the judge will tell me, you know, when my lawyer kind of explained it more of my rights now.
right. So
And my problem is, I have been so inundated with cases. This gentleman and I have not had a chance to sit down quietly and privately and discuss what this process is like. As you are aware from your record, another lawyer was sitting in here on the first hearing.
So
In the meantime, frankly, I've been in this room most of the rest of the time.
frankly, I think it sounds like we probably need to have a little more time, obviously, for you guys to chat. And we have another case this morning that was set that I need to allow to continue.
It's a
Judge
termination.
Costello, yeah, is looking over. So
We have a plea, Your Honor.
yes, what I would like to do is take Ms. Rembert's plea and recess on the question of removal for today. And let you continue talking more about that. We can either come back this afternoon. Or if you want to talk about continuing to let the kids stay with your dad, we can come back. And your dad would be able to supervise parenting time, as far as I'm concerned. Like, there shouldn't be a prohibition against you seeing your children, if that's part of the
My
question.
client likes his dad just fine, but he is opposed to that. He wants his kids back today.
All right, so then
No,
we'll have
I
to
don't
come
wanna-
back this afternoon.
Respectfully, Judge, I'm not in trying to pressure anyone to any legal decisions. I just know this is the first time I was able to get any type of, insight on the case was today. And for 3 weeks without my kids, sitting back wondering and wondering, I finally get in this courtroom. I was just hoping and expecting some type of closure to the allegations that's being held against me. Not complete closure, but at least some understanding.
Right, well, let's do it. I can take up the case again at 1 o'clock this afternoon.
But
Sure.
I want to leave it up to my lawyer. I'm not the lawyer, whatever.
I don't like
Yeah,
going in half-baked, which I have told him I would be doing today. If we went into this right now.
oh, really?
Yes.
Okay,
Right, like, it's my understanding this determination trial is going to go into the afternoon.
okay,
Evening started.
right, well. We're a bit busy here, today. So let me just do this. Let me get Ms. Redford's plea done. Then we'll take a recess and we'll let all the attorneys sit down and try to figure out how to schedule this so that we can try to avoid making everybody who's currently here continue waiting. We'll try to come up with a better plan on schedule, but let's get Ms. Redford's plea done. Is that okay? Any objections? Speak now. All right, Ms. Redford.
Take your seat, sir.
Oh.
Can you hear me okay still?
Yeah.
All right. So my understanding from Mr. McFarland, just briefly before we came out, is that you wish to admit to the allegations in the petition. In other words, you want me to consider all of the allegations in deciding whether or not to take your plea. Is that right?
Yeah,
Okay, so I'm going to go over your rights with you. You have the right to have the petition read in its entirety, or you also have the right to waive that. Would you like me to read it out loud on the record, or would you prefer to waive that?
I prefer to waive it.
Okay. If I accept your plea, you are giving up your right to a trial by a judge or jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses appear and testify under oath at trial. The right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. Do you understand you'll be giving up or waiving the rights I've just indicated to you if you admit the allegations in the petition?
Yes, ma'am.
All right. In regard to the consequences of your plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there's a problem that may be solved, the court can make the children temporary wards of the court, place them with mother or father or with relatives or in a foster home, and order programs for you and your children, such as counseling, drug and alcohol treatment, assessments, and parenting classes. If it appears that you will not be able to provide a proper home for the children in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the potential consequences of your plea?
Yes, ma'am.
Do you have any questions about any of the information I've given you so far?
No.
I understand you're coming to us from a rehabilitation facility today, is that right?
Yes.
Well, congratulations on your continued recovery, but I have to ask you this question anyway. Are you currently under the influence of drugs, alcohol, or anything else that could impair your ability to understand what you're doing right now?
No, I was drug tested. It was all clean. No.
Great. Okay. Is anyone making you admit to the allegations in the petition?
No.
Is anyone threatening you in order to get you to admit to the allegations in the petition?
No.
Okay. Would you say your decision to enter the plea is one you've made of your own free will?
Yes.
Does anyone promise you anything in order to get you to enter a plea?
No.
All right. Very good. As to the factual basis of the plea, Ms. Thomas. Or actually, no, just kidding, because this was going to be a no contest. All right. Mr. McFarland, would you like to, what do your client tell?
Yes, Your Honor. I guess I should say one thing, Your Honor. That'd be number 4, which is the Native American heritage. It says that the subject minors are not members or eligible for membership, and that's up in the air. Just, I think you all understand that.
I do, yes.
Thank you. My client will admit that she's the mother, Your Honor. She will admit the allegations against her in their entirety, including last time we were in court, she wasn't quite sure about all the investigations done by CPS, but she will believe that that will be their testimony on number 18, the CPS history. So that's the only change. And that was going to be a no contest, but we will admit number 18 also, in addition to everything else we said we'd admit last time in court.
Okay. So why don't you give me the summary of the issues that your client and the department will be working together on in order to help restore her to a safe.
Sure. Number one, Your Honor, is a drug addiction. She's in rehab right now. Number two, we anticipate there'll be a psychological evaluation ordered, and then she'll be, that will be incorporated, the recommendations into the case service plan. I anticipate visitation will be an issue, what is available at Harbor Light, who supervisors may be, transportation may be an issue, housing is going to be an issue, Your Honor. Parenting classes are going to be an issue. She has been in the system before, so it'll be understanding what she did not benefit from before and working on those items, Your Honor.
All right. So Malika, did you hear everything that Mr. McFarland just talked about?
Yeah, I do want to state that I did do a psychological evaluation already, and I'm on medication.
All right.
CMH then may also be a component on this, Your Honor. She's on medication.
All right. So it does look, Ms. Rembert, like obviously last time you were here, you were appearing to us from Lenawee County Jail, that you have some criminal matters that need to be resolved, that you need to work on your sobriety, which is why you're at rehabilitation, some parenting skills, and making sure that you're able to maintain housing and employment and safe and clean housing for your children. Would you agree with that?
Yep.
All right, I do as well. Based on my review of the petition, is there anything else that you wanted to say today that you're ready to work on?
Not as of right now.
Okay.
I mean, no, not right now. I would say my mental health, but I'm working on that right now too here.
Great. Glad to hear. All right, are the attorneys satisfied with the advice of rights and the factual basis of the plea?
Yes, Your Honor.
I am, Your Honor.
Does the lawyer or guardian ad litem think it's a good idea for the court to accept the plea, as in it's in the best interest of the children?
I do believe so, Your Honor, yes.
Thank you. The court does as well. I also find the plea to be knowingly, understandably, and voluntarily made with an understanding of the consequences. You'll be able to continue talking about how to tackle the challenges that were outlined today, Ms. Rembert, by way of a family team meeting wherein they'll put that case services plan together. You've seen those before, I know, but I would encourage you to take a look at it, talk with Mr. McFarland about it if you can. And the next time we come back will be for purposes of the disposition, where the court will look at that same plan to determine whether or not it's appropriate and tackles the issues. I also find that the statutory grounds have been met to find that there was a violation of the statute 7112A.2B. I think it's 1 and 2, or whichever subsections specifically the department is claiming, but mainly that the house is, and our environment is unsafe as a result of many of the things that have been talked about. The criminality, the need to address mental health, the condition of the home, and the instability in summary. So the order will reflect those findings. And we can do the initial disposition on your case. Well, I can do it in a couple of weeks, counselors, or otherwise we're running into Thanksgiving. And we may have to ask you to consider waiving your 28 days. It's up to you.
This is a question, Your Honor. Might there be some type of supervised Zoom parenting time or something like that in the interim? Then I think that we would waive the time frame.
Well, the parenting time, I'm sure, will be subject to the facility where she's at.
Correct.
So I would look for the department to have a meeting with them or to really investigate that to find out how Ms. Rembert can best facilitate her relationship with her children.
Your Honor, my client would like the court to know that he and this young lady have not been together for quite some time, which I read between the lines to mean they don't get along.
Okay, well, right now I'm just trying to find a disposition date. So I can do a remote disposition on November 27th at 9 AM. You wanna,
That'd be fine, Your Honor.
Judge, I'm not available, but I think we have this set for a pretrial for dad on some day.
I thought we did too. Monday, the 25th, it looks like.
That'd be fine by us too.
Yeah, if we can maybe set it for just on that day.
All right, let's do that. Monday, November 25th at 9 AM.
And Your Honor, if we could also, when we're off record, get a email address and actual address for my client.
Sure.
My email address?
Hang on, we're not on the record on YouTube, I guess. Are we on YouTube, Your Honor?
Right, yes.
So we'll
So,
wait till we're off YouTube, Malika.
okay, so we're gonna formally recess on this case anyway in just a few minutes. Do you have any questions right now, Ms. Rembert?
No.
Okay, so I'm gonna be counting on the department to work with you to put together your case services plan and to talk with you and wherever you're staying about what parenting time looks like. Is there any other issues between now and we come back that you would need to have me consider?
No.
Okay, well, then that's all for today officially, and